Welcome back to online classes. Dear students, how are you? I am James here. Today I am going to discuss with Indian Penal Code. Okay. Under section 364 of IPC, kidnapping or abducting in order to murder. Okay. Section 364 explain about whoever kidnaps or abducts any person in order that such person may be murdered or may be so disposed of as to be put in danger of being murdered shall be punished with imprisonment for life or rigorous imprisonment for a term which may be extended to 10 years. Okay, and shall also be liable to fine. I will give you illustration. Okay, here A kidnaps Z from India, intending or knowing it to be likely that Z may be sacrificed to an idol. Now A has committed the offense defined in this section. Okay, in this section means section 364 of IPC. And another illustration, A is a person. A forcibly carries or entices B away from his home in order that B may be murdered. Now A has committed the offense defined in this section. This section means 364 of IPC, and punishment automatically what happened? 10 years, maybe extended to 10 years. Okay, student, I think this illustration is very good. We do not want to give any other case and all. Okay, we'll go to another section. Section 364A. What is that? Kidnapping for ransom, etc. Ransom. Okay, here whoever kidnaps or abducts any person or keeps a person in detention after such a kidnapping or abduction and threatens to cause death or hurt to such a person, or by his conduct gives rise to a reasonable apprehension that such person may be put to death or hurt, or causes hurt or death to such person in order to compel the government or any foreign state or international intergovernmental organization or any other person to do or abstain from doing any act or to pay a ransom shall be punished with death or imprisonment for life. Okay, death punishment or life imprisonment, and also shall also be liable to fine. Okay, normally fine will be imposing by the court also. So as per the section, the relevant point out that 364A had been induced in the IPC, Indian Penal Code, by virtue of Amendment Act 42 of 1993. The statement of objects and reasons are as follows. As per the Amendment Act, the statement of objects and the reason means kidnapping by terrorist for ransom, for creating panic amongst the people, and for securing release of arrested associates and cadres assumed serious dimensions. The existing provisions of law have proved to be inadequate as deterrents. In the situation, the Law Commission in its 42nd report has also recommended a specific provision to deal with this menace. It was necessary to amend the Indian Penal Code to provide for deterrent punishment to person committing such acts and to make consequential amendments to the Code of Criminal Procedure Code 1973. That means CRPC. Okay. It is clear from the above the concern of Parliament in dealing with cases relating to kidnapping for ransom, a crime which called for deterrent punishment irrespective of the fact that kidnapping had not resulted in death of the victim. Considering the alarming rise in kidnapping young children for ransom, the legislature in his wisdom provided for significant stringent sentence. Okay, so what are the ingredients need to be fulfilled in this section of 364A of IPC? Here the person is convicted, the prosecution must prove the following ingredients. He has to prove: number one, the accused must have kidnapped, abducted, or detained any person. Number two, he must have kept such person under custody or detention. Number three, kidnapping, abduction, or detention must have been for ransom. To pay a ransom in the ordinary sense means to pay the price or demand for ransom. This would show that the demand has to be communicated. Okay, there is nothing in this provision to suggest that the same is attracted only in ransom situation arising in acts of terrorism directed against the government or any foreign state or international intergovernmental organization. The language employed in the provision is wide enough to cover even case where the demand for ransom is made not as part of any terrorist act but also for monetary gain from a private individual. It is true that if it is a simple case of kidnapping in terms of 363 of IPC, the offender shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Here, the specific charge against the appellant, that means the accused person, to appeal the case, the accused is under section 364A and 120B of Indian Penal Code. If it is established that the offender, after kidnapping a person, keeps the said person in detention or threatens to cause death or hurt in order to pay ransom, undoubtedly section 364A is attracted. Okay, and another point of view, the above ingredients, section 364A of IPC states that apart from keeping a person in detention after keeping or abducting him or threatening to cause death or hurt to such person, or by his conduct giving rise to a reasonable apprehension that such person may be put to death or hurt, and also that if the person involved in the kidnapping or abduction actually causes hurt or death to such person for a ransom. So now he shall be punishable with death or imprisonment for life and shall also liable for fine. Section 364A of IPC therefore contemplates even the death of the abducted person for the purpose of demanding ransom. Okay, what is the meaning of ransom as per this in this Indian Penal Code? The term ransom has not been defined in the code. Okay, stated simply, ransom is a sum of money to be demanded to paid for releasing a captive, a prisoner, or detainee. Okay, the kidnapping for ransom is an offense of unlawfully seizing a person and then confining the person usually in a secret place. While attempting to extort ransom, this is a grave crime is sometimes made a capital offense also. In addition to the abductor, a person who acts as a go-between to collect the ransom is generally considered guilty of the crime only. The kidnapped child was recovered from the custody of the accused by the raiding party. The later demanding ransom was recovered from the pocket of the accused. He had neither posted it nor contacted anybody for the purpose of 3 days till his arrest. So the court said that there was no demand for ransom. An offense under this section was not made out. Conviction under section 363 and section 365 of IPC was proper. Okay. Okay, students. I think this answer is enough. So I think this is suitable for section 364. We'll go to another section. Okay. Section 365 of IPC. What is that? Kidnapping or abducting with intent secretly and wrongfully to confine person. Okay, we already studied a wrongful confinement. Okay, restraint, wrongful confinement, the earlier portion also. So what is that section 365 says? Whoever kidnaps or abducts any person with intent to cause that person to be secretly and wrongfully confined. What happened? Shall be punished with imprisonment of either description for a term which may be extended to 7 years. 7 years jail, and shall also be liable to fine. Okay. So whereas there was sufficient evidence to show that the victim woman was abducted from her house and then taken to different places which included confinement to one place till she was recovered by the police. What happened? So it was held that the accused could be convicted under this section and section 368. Okay, but not 366. Here, where appellant had pushed the informant. Appellant means here accused had pushed the informant into a van, mashed his face with a monkey cap and took him away, and later shifted him into another van, removed his mask and demanded rupees 5 lakhs as a ransom. In this situation, the court found that the evidence of informant is unconvincing, as there is omission to mention material facts in FIR, first information report also, namely earlier incident of extortion and non-mentioning the name of accused, and demanded of rupees 5 lakhs as a ransom. Now the court acquitted the accused. Okay, this was happening many cases. Okay, students, and another point of view, the prosecutrix had left her home voluntarily of her own free will to get married to the appellant. Appellant means that accused appeal, no? Appellant. So that girl, she was 19 years of age at the relevant time and was hence capable of understanding the complication and issues surrounding her marriage to the appellant. According to the version of events provided by her, the prosecutrix had called the appellant on a number given to her by him to ask him why he had not met her at the place that had been pre-decided by them. Now here offense not made out because voluntarily, age also above major, 19 years old. And another point of view of example, the evidence to show that victim was taken away under deceit, DECIT, deceit, and then sold to a brothel house. She was not minor at the time of the incident. Therefore, the accused could not be convicted under section 366 or 372. But they could be convicted under section 365 of IPC, which is in a way a lesser offence and carries a lesser punishment than section 366A or section 372 of IPC. The court suggested that it was for the legislature to address itself this situation in the order of extradition. Section 364A mentioned and not section 365 of IPC. Often under section 365 of IPC is lesser offence than the offence punishable under section 364A of IPC. Hence, protection of accused and trial for lesser offence under section 365 of IPC cannot be held to be without authority of law. The maximum sentence for section 364 and 365 of IPC is 10 years and 7 years respectively. Okay, 364 is 10 years, 365 is 7 years. So the appellant is in a custody for more than 12 years. Court directed that he shall be released forthwith if not wanted in connection with any other cases. Okay, so this type of case also occurring in modern days. Know that point. Actually, that case punishment area is 10 years and 7 years respectively based on the section 364 IPC and 365 of IPC. What happened here? He was already custody more than 12 years in the prison. Okay, so court directed that he shall be released forthwith if not wanted in connection with any other case. Okay, students, I think now it's clear this section also. I am closing the session. Okay, take care. Enjoy with your happy life. Please watch regularly and send your feedback immediately. Okay, bye, see you.